I'm prepared to answer particular questions relating to that.
Well, are you ready to start a criminal investigation into whether this confirmed use of waterboarding by United States agents was illegal?
That's a direct question. I will give a direct answer. No, I am not, for this reason. Whatever was done as part of the CIA program at the time that it was done was the subject of a Department of Justice opinion through the Office of Legal Counsel and was found to be permissible under the law as it existed then. To me, excuse the occasion of the disclosure that that technique was once part of the CIA program, an authorized part of the CIA program, would be me to tell anybody who relied justly on a Justice Department opinion that not only may they no longer rely on that Justice Department opinion, but that they will now be subject to criminal investigation for having done so. That would put in question not only that opinion, but also any other opinion from the Justice Department. Essentially, it would tell people, you rely on a Justice Department opinion as part of a program, then you will be subject to criminal investigations when, as and if, the tenure of the person who wrote the opinion changes, or indeed the political winds change. And that's not something that I think would be appropriate, and it's not something I will do.
Are you prepared to let us get a copy of the Office of Legal Counsel opinion?
The Office of Legal Counsel opinion discusses particular techniques that were part of what it remains a classified program. We have, I believe, provided an unclassified discussion of general legal principles. Did it back in 2004, and we have provided some classified briefings with regard to the legal reasoning underlying opinions, and are prepared to continue to do so. But the opinions themselves can't simply be turned over because they discuss not simply legal reasoning, but the program itself, which remains classified.
Excuse me, for the sake of argument, let's hypothetically concede that waterboarding is in contravention to an international obligation pursuant to the Convention Against Torture. And if an opinion was rendered that amounted to malpractice, that whoever employed that particular technique, simply by relying on that opinion, would or ought not to be investigated, or would be legally barred from investigation and criminal responsibility. Is that what you're telling us?
If you're talking about a legal mistake, there is an inquiry with respect to not the OLC opinions I'm talking about, but other OLC opinions relating to surveillance that relates to whether people properly rendered opinions or didn't. But to rely on an opinion that some later Attorney General thinks is mistaken, yes, this person who so relied in good faith from being prosecuted.
And that I find that position a new legal doctrine, if you will. The law is the law. We can all have opinions in terms of our understanding and interpretation of the law. And if what you're saying, and if we can agree just for the sake of discussion purposes, that waterboarding violates not only American domestic law, but our international obligations under the Convention of Torture, if there are an opinion promulgated by the department, it insulates those who actually perpetrated the act, even ordered the act to be conducted.
The laws you are talking about are phrased in general terms, as to which there is a great deal of dispute. Some people lined up on one side, others lined up on another. If it comes to pass that somebody at a later date finds that the opinion should have been different from what it was, the person who relied in good faith on what the person who arrives later says was an erroneous determination is protected. Because to do otherwise would be to say to everybody out there, You can't rely on any.
Is there legal precedent for that statement that you just made to this committee?
There is a practical consideration.
Are you saying that even if you believe that the law was violated, you lack the power to open an investigation into that?
If I believe that a particular practice is unlawful, then if it's presented to me in concrete terms, I can take steps to say that it's unlawful going forward.
Well, we're presenting.
But
Mr. Attorney General,
are you comment that you made that is very portentous and needs to be corrected, and that is the suggestion that so much as a line of what I said endangers American troops. American troops fight in uniform, carry their arms.
I understand that. I am not, Mr. Attorney General, I am not trying to. Mr. General,
Mr. Chairman, can answer the question?
Yes, but it's my time. I'd like to ask the question, and the Attorney General asked for a specific question. I am not in any way trying to make equivocal or equivalent our troops in the field and what Al-Qaeda is doing. Don't even go there, Mr. Attorney General. But what I am saying is, if we don't establish a bright line in this country that we don't torture, then it makes it very hard for us to argue to other countries that they shouldn't torture our people, period. And I would still like an answer to my question. Why doesn't the Attorney General of the United States have the power, notwithstanding a subordinate lawyer in the Office of Legal Counsel, to investigate whether a crime has been committed if you believe that torture has been committed in violation of the law? Why wouldn't you have the power to investigate that?
We have a bright line. We bar torture. The evaluation of whether a particular practice constitutes torture could be presented to me only in a particular situation, namely whether it was defined, part of a proposed program, in which case I would pronounce on it one way or the other, as I think I am.
And you think that's a bright line that we can hold up to the rest of the world, that it depends on whether it's part of a program authorized by an attorney in Office of Legal Counsel? Is that the standard we would ask the rest of the world to hold up?
We have and do defend our position before the rest of the world. We have people in the State Department who do a superb job at that. And we will continue to do that.
You've said in your Senate testimony that I believe that if you were being waterboarded, you'd consider torture. Does the definition of torture depend on who is being tortured or the circumstances in which they're being tortured?
I said in my Senate testimony that would seem like torture to me. I said that as part of a much larger amount of testimony that indicated, I think, quite clearly that I would not use my own tastes and preferences as the basis for arriving at a legal determination about whether a practice that was actually put before me in concrete terms was or was not torture.
But are you taking the position that whether something is torture or not depends on who is being subjected to the technique and the desirability of the information? Does it vary, or is there simply one standard which is governed by the nature of the coercion?
The question of torture turns on what is in the torture statute, which does not speak, so far as I know, to the nature of the information. It speaks to the intent of the person imposing whatever it is that's to be tortured, and depends on other circumstances.